important topic, and I would encourage you to go get the link to this afterwards and share it around. Julianne does a very good job of explaining what an Article 5 is, and so this is one method to be able to get the message out and so that people understand. And so again, get online and do that. Real quick, this flag here, I've mentioned it before. It's America 250th anniversary. This is a raffle that we're having. We'll actually draw for the flag around the 4th of July. It's a fundraiser for Stand Up for Idaho. If you're interested in it, raffle is $20 a ticket, so we appreciate your support. Okay, real quick, like I say, I'm going to get right into tonight's thing. Actually, not going to be a town hall next week. The Snake River Event Center ended up having a big conference that's going to take up the whole event center, and they said, sorry, but the big conference is actually worth a little bit more than Stand Up for Idaho is for them like that. And so we appreciate them doing that. So no town hall next week. However, the week after, we are going to have Nick Edwards. He's the chief investigator at the Idaho Attorney General's office and a commander of the Internet Crimes Against Children Task Force for the state. He's going to be here in person talking about internet safety and the trends that they're seeing across the state. This is going to be something that's really important, and he's coming all the way from Boise to come and talk to us. They actually contacted me to say, can we come because we like what you're doing. They have a big message to get out. So that's on the 11th. We'll do that. And obviously the political season has begun. Fact is, this last Monday is when people are able to go ahead and register and throw their hat into the ring of they're going to run. And so there's going to be a lot of candidates coming up. One of them, there's a gentleman named Mark Fitzpatrick. He's actually a candidate for governor. He's out of the Eagle area and whatnot. He's going to be in town on the 18th, and he'll be here talking to us about why, like I say, why he's wonderful and why we should vote for him. And so I encourage us all to come and listen to him and ask him the tough questions and hold him accountable. So next few weeks are going to be very interesting, and as it gets closer through the primary season, I'll call it that, we're going to have a lot more legislators, hopefully, or candidates, I'll call them, coming to Stand Up for Idaho. We need to understand who we're voting for, what they stand for, and be blunt about it. Can we really trust them? And so I encourage us all to keep an eye out on those things. Okay, getting on to tonight, Representative Julianne Young. She's actually was a former representative for District 30, Seat B, and she's a wonderful lady. She's running again this year, so we'll hear from her at a separate time on that. But she's here to talk about an Article 5 convention, and there's been some discussion about that. Fact is, the House just a few weeks ago passed a House concurrent resolution, is what it's called, I think, number 25, that says that they would support a Article 5 convention. It went to the Senate, and it's still being contemplated by the Senate. I don't think it got voted on today. So anyway, what is an Article 5? To me, it's a scary thing. And I'm not going to taint Julianne's message right now, but she's going to tell us, as I put it this way, talk to us about an Article 5 and the fallacies and risks associated with it. And let's give Julianne a great big hand, please. Julianne, thank you. Thank you so much for talking to her like this. And you want to get up here so we can see you?
Is it okay if I stand down here, or do you want me up there? I'll do it. You're the boss. Okay. I'll go up here. I am kind of short, so I'm going to have to stand off to the side. That's a given. All right. Well, I am just glad to be here with you this evening and to have the chance to share some information with you about an Article 5 convention. It often is called a convention of the states, but that term convention of the states doesn't actually show up anywhere in the Constitution or in the law. What we're really talking about is a convention to propose amendments to the United States Constitution. Sounds like a pretty big deal, huh? So tonight, I'm not going to tell you whether we should or shouldn't have one, because I really believe that if you know the facts and what the original source records say about a convention, you'll have a pretty good idea of whether it's a good idea or not. So I've titled this an inquiry into fact or fiction, and we're going to talk tonight about what the facts are and about what some of the fiction is that gets spread about these Article 5 conventions. So here's our very best #1 original source right here, Article 5 itself, straight from the United States Constitution. This is the article that tells us how we can amend the United States Constitution. You'll see up there are some different colors, and I put those colors up there just to help give us a little clarity, because this article is one long sentence. Sometimes they go roundabout saying one thing and making sure we get all the details in the middle. But the bones of the sentence say this. In red, the Congress shall propose amendments or shall call a convention for proposing amendments. And we're going to stop right there for right now. So we have two ways to propose amendments in the United States Constitution, or amendments to the United States Constitution. Option number 1 is Congress proposes the amendment. Option number 2 is Congress calls a convention to propose amendments. Everybody can see that, right? So two ways to propose amendments. Then if you go down in the middle there, which in either case shall be valid when ratified by, and here we have two options. In blue, the legislatures of 3/4 of the several states, or in green, by conventions in 3/4 thereof. And then again in red, as one or the other mode of ratification may be proposed by Congress. So all of the red belongs to Congress. The blue belongs to the states. You'll notice up there at the top, it says, on the application of the legislatures of 2/3 of the states, Congress shall call a convention to propose amendments. That's what Idaho is in the process of doing right now, submitting an application for Congress to call a convention to propose amendments. And then you see the other opportunity of the states to exercise some power in Article 5. The legislatures of the states may ratify proposed amendments if Congress chooses, but Congress may also choose ratification by conventions in the states, and we'll talk a little bit about what that looks like before we're done here tonight. So, in green, we have the powers of the conventions to propose amendments, or sometimes we have ratifying conventions. In blue, we have the powers of the states, and in red, we have the powers of Congress. Make sense? So there we go. Does that look like what we just read? Congress can propose amendments. Congress can also call a convention to propose amendments, and they get to choose the ratification method. The states can apply for a convention, and they may ratify amendments if Congress chooses. The convention, a convention in Article 5, is empowered to propose amendments, and a convention in the states may also ratify amendments. Those are two different conventions, but both called by Congress, as we'll see before we're done here. So it's really important for people to know exactly what Article 5 says, because there are a lot of things that get put out there about what it means to call an Article 5 convention. And the main narrative is Congress is bad, they are failing They are out of control, and they will not fix themselves. And so we, the states, are going to empower Congress to call a convention to amend their governing documents so that we can take back our power. And they don't really tell you all of that, but that's what Article 5 says, because we just read it, right? So, I apologize to those of you like me that are starting to have difficulty reading. I debated about putting all of these words on this slide, but I am really big on original sources, and I find that when I share information with people, sometimes they come back after the fact and they say, well, it doesn't really say that. So, I want you to have the original sources and be able to read them for yourself. If you can't see them super great on this screen, we will share the slides. These are excerpts taken directly from the minutes of the 1787 convention, where they adopted our current U.S. Constitution. And these are the statements that are part of the record about the addition of that convention option to propose amendments in Article 5. There's not much else about it. It didn't even get brought up until the last day of the 1787 convention, when they were reviewing the final draft of the Constitution. And when they get to Article 5 in the draft, that version read like the italicized language at the top. The Congress, whenever 2/3 of both houses shall deem necessary, or on the application of 2/3 of the legislatures of the several states, shall propose amendments to the Constitution. Do you see what's missing? What's different? There's no convention there. And I think there is still ratification language. See the comma there at the end? But I was pulling out the part that shows you what's different. What's different is there was no convention to propose amendments. In either case, whether 2/3 of both houses deemed it necessary or 2/3 of the state legislatures applied, Congress proposed the amendments directly. That's the way Article 5 read on the final day of the review. Then we had this big struggle going on between the anti-federalists, who were very nervous about this new federal government, and the Federalists, like Alexander Hamilton, that wanted a strong federal government, right? And Colonel Mason was an anti-federalist. So he brings up this concern. I put as much of the statement as I could reasonably fit on the slide here up there, and then in blue you'll see his main point. His concern was that no amendments of the proper kind would ever be obtained by the people if the government should become oppressive, as he verily believed would be the case. Now, I want you to see this in context here, because those promoting an Article 5 convention to propose amendments are telling people that the founders put that convention option in the Constitution so that the states could rein in an out-of-control federal government. So look at that statement. Is that really what Colonel Mason said? Did he say the states need to call a convention to rein in an out-of-control federal government? Not quite. What he's really saying is the states might not be able to get the amendment they want if the federal government is out of control. That's a little different. After Colonel Mason brings up these concerns, then Governor, and his first name was actually Governor Morris and Mr. Jerry moved to amend the article so as to require a convention on the application of 2/3 of the states. That motion passed. And so the phrase, "or shall call a convention to propose amendments," was inserted into Article 5. Then, I think this comment from Mr. Madison is very important, because people will often say, the founders put Article 5 here to save us from an out-of-control federal government in their great wisdom, and surely they intended us to use it. I want you to see the only comment here coming from someone that's not an anti-federalist, from Mr. Madison, who did not see, and this is direct quote, I'll share the link if anybody wants to look it up, did not see why Congress would not be as much bound to propose amendments applied for by 2/3 of the states as to call a convention to propose amendments. So he's basically saying, Colonel Mason, Mr. Morris, Mr. Jerry, if Congress isn't going to do it, Congress isn't going to do it. And it doesn't matter if you're telling them to propose amendments or to call a convention to propose amendments, you still have the same problem, and I'm not sure you've solved it. But he saw no objection against providing for a convention for the purpose of amendments, except, and this is important, he did have a concern, except only that difficulties might arise as to the form, the quorum, etc., which in constitutional regulations ought to be avoided. Now think about this. These are men meeting in a convention as representatives of we the people, exercising government-making authority. They recognize that it would not be appropriate for one old government to tell the next government exactly how to do things. Because if a convention is called in the future, that convention will represent the people. And they will make their own rules. And they will determine how to do things. Those decisions belong to the people of the time, not to James Madison. And so he believed it wasn't appropriate to include that, but he did have some concerns. And we're going to talk about some of those as we go along here. So that right there is the full extent of what we know about why this language was put in from the direct minutes of the 1787 convention. Now, what's super interesting is that immediately after they insert the convention language into Article 5, Colonel Mason stands up with another concern. This time he says, the Constitution has been formed without the knowledge or idea of the people. A second convention would know more of the sense of the people and be able to provide a better system. So he turns right around and he says, okay, now that we got the convention language into Article 5, I want you to know that I want another 1787 convention. Charles Pinckney stands up and says, nothing but confusion and contrariety could spring from the experiment. The states will never agree in their plans, and the deputies to a second convention coming together under the discordant impressions of their constituents will never agree. Conventions are serious things and ought not be repeated. He was not without objections to the plan. Let's see, he goes on talking about how he knows the Constitution isn't perfect. He has his own reservations. But apprehending the danger of a general confusion and an ultimate decision by the sword, he should give his support to the Constitution as it then stood. He recognized that it was not in his view perfect, but it was time. And it was time to accept it and move forward, because dragging it on with a second convention risked the sword. That's how he felt. That's how. Now, here's the other thing. On the question of Mr. Randolph's proposition, all the states answered no. The anti-federalists were outvoted even within their own state delegations, those that wanted another convention. So it was unanimous in opposition to the idea of calling another convention in 1787. And then immediately after that vote, the next vote was on the question to agree to the Constitution as amended. All states say aye. And then after that, we have the debate about who's going to sign and who's not. And we have some delegates who did not sign, including Mr. Jerry and Gouverneur Morris. Interesting. So now you know the history of Article 5, more than most people know. Okay, the question is, what did Mr. Randolph propose? Okay, let me clarify. It was Mr. Randolph so the way that the record goes, Colonel Mason voices his objection, then Mr. Randolph makes a motion that they have a second convention. And then Mr. Pinckney responds to that. So thank you for that question. It is a little confusing. Okay. So that's what we know about the history of that language. Now let's talk about the second half of Article 5. I have watched those lobbying for an Article 5 convention tell legislators repeatedly that no bad amendments can come out of an Article 5 convention to propose amendments because or none of them can survive, because they have to be ratified by 3/4 of the state legislatures, and 3/4 of our state legislatures would never ratify a bad amendment. Now, whether you believe that or not, legislators are inclined to believe it because we like to trust ourselves. But the thing that bothers me is I have even stood before a committee and given testimony that there is not a guarantee that state legislatures will have a chance to ratify. And those arguing for these resolutions have closed the committee hearing by again assuring the legislators that legislatures will have to ratify. They completely deny in too many instances that there's even a second ratification method. Don't you think that's kind of important? I think it's important, especially since Congress controls which ratification method is used, not the states. So, Congress may choose ratification by conventions, and this we actually have historical precedent for. All of our amendments have been ratified by state legislatures except for one, the repeal of prohibition in 1933. And if you look up the historical record on this, you'll find that it's broadly acknowledged that Congress recognized they would not get 3/4 of the legislatures to sign off on the repeal of prohibition. And so they chose the other method, ratification by conventions in the states. And I have known for many years that Utah, which was one of the driest, most anti-liquor states in the country in 1933, produced a convention that unanimously supported the repeal of prohibition. And I've always thought that was so mysterious, and I never understood, though, how it actually happened. It just was an evidence to me that this is not a foolproof process. Well, now I know. I actually discovered this last summer that Utah and Idaho still have statutes on the books today that outline how those ratification conventions were organized. Let me tell you how they did it, and then I'll talk about this little excerpt from that statute. They organized 2 slates of candidates that would go on the ballot. One group of 21 delegates that were committed in advance to support repeal, and one group that was committed in advance to oppose repeal. Then the statute directs the governor to choose a special election date that did not have to align with other election dates. And they had a popular vote where one side or the other side took the entire slate of delegates. All they had to do was get 50 plus little bit percent of those turning out in an off-cycle, low turnout election to support repeal, and they produced, voila, a unanimous convention. Here's the crazy thing. 38 out of 39 states produced these unanimous conventions in support of repeal at a time when Congress didn't think they could get 3/4 of the legislatures to do the same thing. Interesting, isn't it? That's the history around ratification by conventions. But there's even more here that is troublesome to me, and that is this. I have not read the statutes of all of the states, but it appears that they are very similar. Both Idaho's and Utah's have a section on federal supremacy in regard to the ratification convention. This is the language from Idaho's 1933 statute. Federal statute to control. If at or about the time of submitting any such amendment, Congress shall prescribe, and I'm going to skip to the bolded there, Congress shall prescribe the manner in which the convention shall be constituted. This act shall be inoperative. The convention shall be constituted and shall operate as the said resolution or act of Congress shall direct. And then it goes on to say that any officers of the state should act under the direction of Congress with the same force and effect as if acting under a statute of this state. Does that sound like we're empowering the states? It doesn't sound like it to me. And here's the other thing. If this is our historical precedent, and a modern Congress were to choose ratification by conventions, you would assume that they could assert the same authority today. And maybe they would pick the same model we used in 1933. But maybe they wouldn't. Maybe they would have some other thing up their sleeves to help things go the way they wanted it to go. Let's say we actually had a convention and we got a really great amendment out of that convention that was going to really crank them in. But they control the back end of the process. How are we to expect that they would not run it right into the ground? Or vice versa. If we got something that was really going to expand their power that they really liked, why would they not ensure that it passed on the back end? So here's some things to think about. You've seen the original language of Article 5 now. Some of this is speculation on my part and yours, because we have never had a convention to propose amendments called under the authority of Article 5. Now, private organizations have held their own little mock conventions, and they've created rules and they've proposed amendments, but never under the authority of the Constitution. It's all been just show, fun and games. So, who determines which state applications for a convention to propose amendments will be counted? What do you think? Based on what you know, the little bit that Article 5 tells us, who is going to decide which applications to count? It has to be Congress, right? It has to be Congress unless somebody takes it to the Supreme Court and says, Supreme Court, you have to make Congress count them. But how much detail is there in Article 5? The only phrase is, on the application of 2/3 of the states. It's silent. It doesn't say the applications have to have one amendment in mind, does it? It doesn't say single subject amendments. It doesn't say identical language. It says, upon the application of 2/3 of the states. Who decides that? Not sure. Who determines how the delegates are selected? Well, if Congress is going to call the convention, who's going to say what the convention is? I think it's reasonable to assume that Congress would have to say who they're calling. Who determines the apportionment of the votes in the convention? Who decides if it's by population or one state, one vote? If Congress is calling the convention, doesn't Congress have to determine that? There's no one else I can see in Article 5 that could make that decision. Who's going to set all of the initial parameters for the convention? It has been one state, one vote in the private organization conventions that have been held. But we have no historical precedent for a convention called under Article 5. What we do have is research by the Congressional Research Service that has asked this question, and we have congressional proposals over time because states have been proposing or applying for a convention to propose amendments throughout our nation's history. That's the truth. And Congress has asked some of these questions. But according to the Congressional Research Service, most congressional proposals for a convention to propose amendments favor distributing votes based on population, not one state, one vote. Now, could it be one state, one vote? There's a chance. There's a chance. But when it comes to questions like this, I favor the perspective of Rex E. Lee, who was the former dean of BYU Law School. When he got asked some of these questions, he said, the only certain thing that can be said, and I'm paraphrasing here just a little bit, the only certain thing that can be said is that no one knows. And anyone who purports to advance a definitive view is either deluded or deluding, because there is no way to know. Who funds the convention? The Congressional Research Service says that Congress expects to fund the convention. Who else would fund a national convention? And sometimes we say, if you want to follow the power, you follow the money, right? Who staffs the convention? Congressional Research Service documents tell us that Congress expects to allocate staff for the convention. Here's one that we do know definitively from Article 5. If a convention is called, who proposes amendments? The language is crystal clear. It's a convention to propose amendments. That's the name of the convention. That's the purpose of the convention. The convention proposes amendments. And the language amendments is plural. Did you know there's actually been a congressional proposal that we amend Article 5 to read a convention to propose a particular amendment? it's been proposed. Somebody's looked at that language and thought, boy, I don't know if I like them being able to propose amendments plural. But the fact is that language has not been adopted. That's not what Article 5 reads right now. The convention proposes the amendments, and the convention is empowered to propose amendments plural. There is no limit on the number of amendments they may propose in Article 5. Now, some people will say, well, we, the states, are going to commission our delegates, to which I say maybe and maybe not, because we don't know how those delegates will be chosen. But we are going to commission our delegates, and if they don't do what we want, then we will discipline them and we will tell them to leave that convention. Now let's think about that for just a minute. We are Idaho. Let's say we get lucky. Let's say it's one state, one vote. And let's say we show up at the convention and things are going in a bad direction. And our delegate knows what their charges are, and they are determined to be true to their charges. So Idaho's delegate walks out of the room. He says, I'm done with this. Has he changed anything? Has he disempowered the convention? Has he disassembled the convention? No. There's nothing in Article 5 that would allow even a delegate that's at the table that doesn't like the direction the convention is going to change the direction. Interesting to think about. And then, again, at the end, who chooses the ratification method? And we know that is Congress. So, this is the other thing that I want you to be aware of. And this one I didn't want to put in a slide, but I will give you a link to it. One of the things that has troubled me a little is the disconnect between what good people are being told on the ground in the states and what's happening in Congress. Right? We've talked about already the discrepancies between the Congressional Research Service documents and what proponents in the states are saying. This right here is a congressional resolution that was proposed February 24th, 2025. In Congress, they have 2 years to do business, so this resolution is currently assigned to the Committee on the Judiciary. This is a live document right now. A concurrent resolution calling an Article 5 convention for proposing a fiscal responsibility amendment to the United States Constitution. So these are balanced budget, folks, just like the balanced budget amendment that's being proposed, or that we're being told we want to apply for here in the state of Idaho. So it goes on to talk about Article 5. Then it says, whereas congressional and state records of plenary applications for amendments on any subject and applications for the single subject of inflation-fighting fiscal responsibility amendments. Turn the page here. According to congressional records, these add up to 39 applications by the end of 1979, 40 in 1983, and 42 total applications over time. So this group has gone through, they've added up all of the past applications, and they're arguing that we've had as many as 42 live applications. Now, how many applications did it take to call a convention? 3/4 to ratify, 2/3 to apply. 2/3 of 50. 34. They're claiming that we've had as many as 42 live applications at one time. Then they say, whereas Alexander Hamilton in Federalist 85 stated, the Congress shall call a convention. Nothing in this particular is left to the discretion of that body. That's an Alexander Hamilton quote. Then they say, I'm going to skip through here. So the Alexander Hamilton thing is pointing out that if that number of applications exists, Alexander Hamilton said Congress has no choice, right? And then they say, call for a convention. They list the timing, and then they have a section, ratification of amendments by the states. So first of all, I'd like to point out here, are these single subject applications that they're putting together? No. They're calling for the aggregation of different subject applications. And then here, ratification of amendments by states. Each proposed amendment at the convention for proposing amendments called under this section shall be ratified by a vote of we the people in 3/4 of the states via state convention delegates who shall have no ground for reversing the vote of millions of its citizens. So, this current congressional proposal is calling for, first of all, the aggregation of all existing applications, and even going backwards, calling for a convention based on previous applications, and they're calling for ratification by conventions. And they are referencing specifically conventions as were held in 1933 by a vote of the people for a slate of delegates who shall not reverse the vote of the people. So this convention, this ratification convention, is not a deliberative body. Here's an interesting thing. I found a newspaper article from 1933, right after that election was held. And the headline of the column said, "Light Turnout Election." And then they commented down in the body of the article that although there would be a convention, it was a mere formality. They used that language. So, why is it that these discussions, these proposals are being made in D.C. to Congress, while state legislatures are being told it has to be a single subject application? You will get to ratify. Why is the information not the same in both places? And here's one last thing for you, just some food for thought. Some of you might be wondering how many active applications there are out there. Now, depending on the group you talk to, they'll tell you their number. The number of people asking for a balanced budget, the number of states asking for term limits, the number of states. Did you know California has one calling for gun regulation? An amendment for safety's sake. The only thing I could say for certain about counting these applications is that the only states that don't have an application and can't be counted are the ones that have currently rescinded all of their previous applications. So this is the list of who has rescinded their previous applications and the dates that they rescinded those applications. And then only one state, Hawaii, has never passed an application for an Article 5 convention. So how many states does it take to call a convention? 34. If 16 states have rescinded all of their previous applications and 49 states have submitted an application of some kind at some time, and only one state has never applied, where does that leave us? 33. Now, I don't know if they can do what this congressional resolution is proposing and go back to 1982 or 1974 or whatever it is. But I have to ask myself, if I was a Supreme Court justice in 2026 and someone brought a case to me and said, Idaho or Virginia or whoever off this list just passed a resolution calling for a convention, and now there are 34 states with an active application, Congress has to call a convention, and I was a Supreme Court justice and I'm not, and you can think about what you would do. I would scratch my head and I would say, boy, all it says is 2/3. Have we crossed the 2/3 threshold? Well, I guess we have. Will that happen? I don't know. There's so much about this that I don't know. But I have to wonder, is calling a convention to propose amendments really an effective way to increase state power? Or is it a recipe for chaos and instability? As a country that is already incredibly fractured and divided, struggles over questions like the apportionment of votes, the aggregation of applications, the ratification of amendments, and who thinks it was corrupt and who thinks it was good. The legal fight over this issue alone could cost us a fortune, not just in money. So, we're all free to draw our own conclusions here. But I can tell you that I see nothing in the historical record or the congressional record that gives me a lot of confidence that this is the answer to our problems. And I see a lot of things that give me grave concern. My dad's a doctor. He actually passed away last year, and I miss him a lot. But he worked in the ER. And a lot of the people promoting this kind of stuff will say, in fact, the analogy got used in the House. When a patient comes into the ER, sometimes you have to get out the paddles. And the message is, we have to have a convention because America is headed for life support. I think a better analogy is this. Our Constitution is the heart of our country, not whatever problem they're talking about. And our Constitution is good. And if we'd follow it, most of the time we'd solve the problems they're talking about. So to me, it's more like a patient comes into the ER with liver failure, and a panicked physician does open heart surgery because doing something feels better than doing nothing. Sometimes doing something isn't the best thing. Thank you so much for being here. I'm happy to take some questions. If anybody has any questions, I know Doug wants to get things recorded well, and I want to make sure we're good on time.
You're real good on time, no problem. Let's give her a great big hand.
I'm Ernie Tate. My question is, if Idaho passes this in the Senate, that gives us the 34th state to send this on to Congress. And if there's 34 different ideas come from 34 different states and goes to Congress, then what is Congress's ability? They can come up with anything they want? Is that what I'm understanding? Or do they have to pick through what these states have ratified, and obviously the states have not all ratified the same questions, or the same?
Yeah, that's a good question, Ernie, and this is what I understand. So Congress is going to call a convention. These are applications to call a convention. That's the guts of it. So Congress will call a convention to propose amendments, and then the convention would be responsible to propose whichever amendments they could get a majority of the delegates to support. In my mind, if you're asking Congress to propose a specific amendment, that's a little different. But if you are asking Congress to call a convention to propose amendments, your amendment is one of many that may be considered.
Now, does Congress have to call for a convention if the 34 states request that? Are they required to call for the convention?
Thank you, Ernie. What I can tell you is that the Article 5 says Congress, upon the application of 2/3 of the states, shall call a convention. And typically, in legal language, shall is considered mandatory.
Dennis, I have another question right here from a lady.
How do we get rid of birthright citizenship if we don't have a convention of states? I don't support the convention of states, but I want to know how we can get rid of birthright citizenship.
All right. Thank you. The thing that makes sense to me is that if we want a change and we don't want a convention, the other option is to get Congress to propose the amendment, which is how all of our existing amendments have been proposed up to this time. So, yeah.
I'm Dennis Summers. I'm an old retired guy and a precinct volunteer. I spent 2 weeks in Boise when this session began. I spent time talking to a bunch of those guys who were in the know, and they showed me a report that $10 million is going to the effort in Idaho to hire the lobbyists that they have. And the lobbyist guy who's working over there, he wears a veteran's jacket and got all kinds of badges on it. He's from Wyoming, and they are putting forth a pretty good argument. But the $10 million reminds me of the Rocky Mountain heist, where if you spend enough money, you talk people into doing things, and then you get to do what you dang well please. Have you heard some of those same arguments that they're just putting a ton of money into Idaho right now?
Yeah, you know, what I know is that I've watched this issue go around a few times now during my service, and I know that the legislators are feeling an immense amount of pressure from a large number of lobbyists. It's one of those issues that people have heard enough about that they're just sick of it and really frustrated. And the other thing I know is that groups that are supporting a call for a convention are weighing in on some races. And so, for example, Representative Judy Boyle has been very outspoken in opposition to a convention, and they put $200,000 into her race against her because of her position on this issue. And that's just one race in one state in this great big country. They're bringing people from D.C. to Boise to lobby in addition to the regular paid lobbyists. Yes.
Have we defined who they are? Who's putting up this money?
Yeah.
Is it one group or is it many groups?
The money is coming on the outside from many different groups. I know some folks have done more of a deep dive into the funding behind this. That's not information that I have at my fingertips right now. I've seen it in the past, but I would have to say several different directions is what it appears to be. Oh.
Even when you read a name, It doesn't make a lot of sense.
Okay, one thing that nobody ever brings up, but I'd like to mention, is Congress has passed balanced budget laws in the past. In 1997, they passed the Balanced Budget Act, which was supposed to balance the budget by 2002. And have we noticed how well they have obeyed their own laws? So even if they had a convention and this was all straightforward and they passed an amendment to balance the budget, do we really believe they would do it? They will not even do it when they pass it. And so it's such a moot point.
Thank you. Thank you for that comment. You know, the one thing that I can add to that comment is that Congress pays for things by printing money. They're not operating on a balanced budget in the same way that we do here in Idaho. And so there are a lot of questions around this idea of balancing the budget. Now, do I want Congress to rein in federal spending and bring down that debt? Absolutely. And that's why this issue sells. Because everybody wants that. But how do we do it? And who has to figure out how to do it? If the amendment gets passed, Congress. And California's idea of how we balance the budget, if they supported it, might be different from Idaho's idea of how we balance the budget, might be different from New York or Virginia or Florida's idea of how we balance the budget. So at the end of the day, even if we had balanced budget language, we would be a little foolish to assume that it was just going to automatically fix everything. At the end of the day, the solution still rests on the shoulders of the same people we're so frustrated with that lead us to think we need to call the convention. Any other questions?
My name's Ethan Neff, and I have a question about this. I've been wondering, and correct me if I'm wrong on this, isn't the Convention of States essentially the same thing as bringing us back to what was happening in 1787, where if the delegates so desired, they could completely scrap the Constitution? Couldn't they just completely get rid of it or rewrite it completely? Isn't it the same thing as was happening in 1787, which is, in my mind, why I think it's so dangerous?
Thank you, Ethan. That is a great question. You know, those in favor of this kind of mock people who make comments like that as you're afraid. You're afraid of a runaway convention, and you need to have more faith and more courage so that you could support this. Here's the thing, and I'm glad you asked this question because I think it's important to understand. When they met in that 1787 convention, they had commissions from their states. We can still read their commissions, and they had discussion about whether they should or why they should or should not depart from their limited mission that they had been given. And I think this point is so profound. Every high school student should learn this in their government class. The founders made a deliberate decision to go a different direction, not because they felt they were violating the trust of their states and their state legislatures, but because they determined that they were acting not based on the authority of the states back home, but under the authority of the people. And so James Madison got asked one time whether the states were supreme or the federal government was supreme, and he said, no, you're missing the point. This is in a beautiful letter to Edward Everett, I believe is the man he was writing to. He said, our form of government is completely unique from any other form of government in the whole world because the same group that created the state governments and authorized the state governments created the federal government. Not the people people of the whole country creating the federal government, but the people in the several states. The people in each state created their state government, and the people in each state as a body ratified and approved of our federal constitution. And so they are truly separate and co-equal because they derive their authority from the exact same source. Madison was clear. Contrary to what we often get told, the states did not create the federal government. The people of the states were the source of federal power, just as the people of the states were the source of state power. Isn't that profound? And here's another evidence of that principle in action. The Articles of Confederation, which was their first national government, or they wouldn't have called it a national government, their first confederation, after the Revolution, began with an acknowledgement that they operated as the states, and I wish I could remember the exact language, but it's something like "we the several states," right? But when they wrote the preamble to the United States Constitution, they did not say "we the several states." No, they said "we the people of the United States of America." And that is appropriate from their paradigm, because who holds the authority? It's in the Declaration of Independence. To institute new government, laying its foundations on such principles and organizing its powers in such a form, who holds that? The people. A convention in 1787 determined that they could act based on the authority of the people. And that is our nearest historical precedent. Not these other conventions that have been held by private organizations. Yes.
To answer his question, there is a fundamental difference here. When they were meeting in 1787, they didn't have a constitution. Article 5 is part of the Constitution, and it specifically says to propose amendments to the Constitution, not to scrap the Constitution. So I don't think anybody would consider scrapping the Constitution would be within the realm of Article 5.
All right. If you don't mind, I'd like to respond to that with just a couple of thoughts. In 1787, many of the delegates felt that what they were doing was outside their charter from their states, and that's clear. And they did make a decision to go a different direction. They also made a conscious decision to choose a ratification method that was different from the ratification method in the Articles of Confederation. That was also a conscious decision. They amended their own ratification method. Interesting. Yes, I'm happy to take a question.
Okay. I got probably more of a comment than question, but thank you for not calling it a ConCon, which has been mentioned in a constitutional convention. It's not. It is a convention for proposed amendments. And there's been several state constitutions through the years, or state meetings, conventions through the years. There's been like 38 of them, like all the people along the Colorado River for water rights and whatnot. And none of them ran away and destroyed our country. That they always do like Robert's rules, because people know that's why they didn't, in the Constitution, they didn't have to spell everything out, because they weren't stupid and they didn't think we were stupid. So they just like, this is how meetings are always done. You know, they convene, they pick officers, they pick committees, they do all the normal things like our legislature does. So it's not going to be somebody coming in there, all right, let's get rid of the Second Amendment. It doesn't happen that way. I'm gonna say it. You said we would say fear. Now I think it's fear mongering actually, that would happen. It just wouldn't happen. And it
Right.
is.
Is there a question?
And then the ratify. They wouldn't have a. They can be ratified by a state two ways, and as soon as we put an application, that's why I'm with Convention of States, but I support the other Article 5 ones because I think we just need to have one, and people can see it's not going to be all chaos. It just won't be, and our proposal has 3 specific areas of subject matter, and it would and they have to stick to those. I mean, that's part of the application. Our applications are the same in every state, so that there's not, like somebody was saying, that there be proposals for all different kinds of things.
All right.
So
Thank you for your comment, and let me be clear for sure. Thank you for being here. Thank you for caring about our country. Thank you for working to make a difference. I
And,
recognize.
Michael Ferris,
Yep. Thank you so much.
he's the one that's got school choice.
Yep. Thank you.
He argues before and he's one of our guys.
Yeah.
He argues before the Supreme Court on all that. So
Yes. Thank you. Thank you for being here. And I want you to know that I appreciate and respect that there are a lot of people who love our country who are supportive of this idea. In my mind, when you have something that's very precious, you weigh the risks very carefully. And choosing to be careful with something that you care about is wisdom. A little bit of fear can be wise. So, I've shared with you the original source documents. You've heard some of the claims tonight. You see what Article 5 says. You can go home and read that. I'm happy to share some links to the 1787 convention, to the congressional documents, including the Congressional Research Service. And at the end of the day, we all get to consult our own conscience and determine for ourselves what we feel good about. So thank you for being here tonight so that you can make an informed decision.
Thank you. Let's give her a big hand. I need to make a couple comments too. I get the opportunity to do that, I guess. Thank you so much. I ran for state senate a couple of times, and I actually had the chairman of the organization pushing term limits call me. And he was talking to me about whether they were going to support my campaign or not. And I asked him, well, I told him I don't believe in an Article 5. And I asked him, what assurances do we have? And just tell me, what assurances do we have? And after about a half hour of discussions with him, he boiled it down to this basically, and he says, Congress will never let it happen because they're going to be too afraid that they'll lose power. So they'll never let it happen. And my comment to him at that time was, because he couldn't give me any assurances, I said, so you're asking me to play chicken with the Constitution. And if you're, I don't know if you know what playing chicken is, and in my day, it was two stupid kids, driving 100 miles an hour towards each other, so who's going to swerve first. That ended that conversation. Needless to say, I did not get their support, which is okay. Another thing, I have reached out to the Convention of States folks, the National Level, Meckler, Ferris, all this, said, let's have a debate. Let's have a debate. Let's talk about it. Because I'll profess, and I'll tell everybody, I know nothing. Let's have a debate. Let's talk through this. Let's have the discussion so that we can really decide what is right. They flat refused. They handed me off to the Idaho State's chairperson for their organization and whatnot, and I forget what her name was because it was a couple of years ago, and she said flat refused to debate. We need to understand, and to me, I was talking to a guy the other day, and you know what? No debate, that means no discussion. Okay? Well, if there's no discussion, then no Article 5. If it truly is, and I am just as passionate about our country and our Constitution being out of control. How many of you watched the State of the Union address last night? Okay? That was Congress. You trust them, all of them, and I'm not picking on one side of the aisle or anything. You trust them. Half of the people there refused to stand up and say that the purpose of government was to serve the people of America. Half of them did that. I'm looking at that, those people, okay? That is why we have the problem. It was said earlier, our Constitution isn't the problem. It's the people that we send there that supposedly represent us and are supposed to be taking care of us and looking out for our best interests in accordance with our Constitution. That's not happening. And I don't care which side of the aisle you're on, the thing that was, in my mind, demonstrated so much last night was the lack of unity and the bitterness on all sides. And heaven forbid that we end up giving that body the opportunity to potentially, because there's no assurance that they'll follow Robert's rules, there's no assurance they'll do this, there's nothing in Article 5 that says this will be this. How can we rely on them? You know, it really does sadden me. This is the 250th anniversary of the founding of our country, of the Declaration of Independence. And we're having this discussion. We actually should be celebrating and thankful that what we have and where we are. Because I'll say this, and I've said it before, none of us would be sitting here tonight if it wasn't for what happened 250 years ago and the preservation of our Constitution. And actually, I am not willing to play chicken with our Constitution. Okay? And I encourage this, and I ask you, these people here that are to support it, let's have a debate. Let's hear both sides. Let's get Meckler, Ferris, whomever, here with some other constitutional scholars. Let's have the discussion. Let's get it all out on the table. Let's really see about it. I know I'm willing to do that. I know that a lot of constitutional scholars that are willing to do that. I'm sure Julianne would be willing to do that. Let's have the other side come and do that. And until they decide that they believe in their position strong enough to actually come and have that debate, then again, in my opinion, no debate, no discussion, no Article 5. Okay? I'm sorry, I am passionate about this. I want some change. I want change in our country. I want change what's happening in the state. Look at who voted for that resolution in our House. In my mind, every one of them that voted, yeah, we're going to do this, is saying we're going to play chicken with the Constitution. Well, to have a hard look at them. Are they looking out for us, or are they looking out for themselves, or whomever? Because this is a serious thing. Or are they playing politics? Oh, yes. Everybody wants a balanced budget. We all have to have a balanced budget. It's a good thing. Da-da-da-da-da-da-da. Yeah? Well, you know what? And I look at it this way. Once I pull that trigger, I can't pull that bullet back. And we sure as heck need to know where that bullet's going to hit when we pull that trigger. I hope that our senators watch this and are looking at this and that they vote no. Because, yeah, am I a fearmonger? Yeah, maybe so. Because I am fearful because of the things that I saw last night, that yes, there's this chance that we will walk away with our Constitution will go away. There's nothing that anybody's willing to be able to show me that it can't go that route. And I'll borrow from Charlie Kirk. Prove me wrong. I encourage Meckler. I encourage conventions. I encourage the people. Prove me wrong. And if you can't prove me wrong, then are you willing to play chicken? Well, I'm not. Thank you, Julianne. Let's give her a great big hand and whatnot. And I do appreciate it. Again, next week we're not going to be here, so take the break. And the following week, it's a really important thing. There's a gentleman coming over from Boise to talk about internet crimes against your children. There's a lady back here, and I'm going to make her go back towards the door, and so she can catch on the way out. She actually has a petition. She's working with the trying to get enough signatures to repeal the grocery tax. And so if you're in favor of repealing the grocery tax, you need a petition. She's trying to get a petition signed to do that. See her, sign the petition. We'd appreciate that. The 18th, we're going to start our candidate forums. And we're going to have Mark Fitzgerald. He's going to challenge, he's one of a few challengers against Governor Little. And we'll start with him, and as they say, we'll let the games begin. Thank you, everyone. Have a great night and everything. And let's give Julianne another big hand. Thank you so much, Julianne.